Okay, folks, I'd like to welcome all of you to learn about how the Office of Attorney General, with the assistance of DCRA, prepares its slumlord litigation. I'm Dennis Taylor. You can't tell it, but I wanted to make sure everyone could see me and not have to look at my name here. You said you didn't bring yours. No. Anyway, I'm the General Counsel for the Office of Tenant Advocate, and I am pleased to be joined here on my left, Mr. Jimmy Rock, who did use his right name, who is Deputy Director, is that it? Deputy Director of the Office of Attorney General, Office of Consumer Protection. On my immediate right, Ms. Jane Lewis, who is Section Chief for the Housing and
Community Justice section.
Thank you. And on my far right, Mr. Ferdinand Gamboa, what is your official title these days?
Housing Inspection Program Manager.
He's in charge of housing inspections, and he works out of the Department of Consumer and Regulatory Affairs. Okay, first of all, I'm a little bit confused about one little thing having to do with this session. I've been reading District of Columbia law for 10 years. I've never seen the term slumlord. Jane, what's a slumlord?
Well, slumlord is not a legal term. It's a descriptive term.
Well, tell us, what is the legal term that would have to be a slumlord?
Well, there's no single legal term for that. The fact is that all property owners who rent to tenants are landlords, and all landlords are obligated to comply with the district's housing code, property maintenance codes, fire codes, etc., that ensure people a minimum standard of health and safety and decent habitable housing. So the respondent defendants in our cases that you might refer to as slumlords are people who have chronically failed to live up to that minimum legal standard.
Okay, well, there's got to be some legal word that goes with what you do. What is that legal word?
I think you're thinking of receivership. The Tenant Receivership Act is the main law that our office uses to go after these slumlords, these property owners who have chronically neglected their properties. And essentially a receivership action is one in which the Office of the Attorney General, or a tenant group, because tenant groups can also bring these actions, one in which the Office of the Attorney General is petitioning the court to take the landlord or the property manager out of the picture and put in place a receiver who is an appointee of the court to handle the day-to-day property management tasks in a responsible way.
Okay, now, so Jimmy, would it be fair to say that if a person like me is saying this is a slumlord case, you're probably bringing a receivership case?
So I think the sort of the basis of your question is, why are Jane and I both here? Why are there two people from the Office of Attorney General here? And that's because there are two different statutes that are at issue that the Office of Attorney General has that can be applied in a slumlord case. The primary statute is the one that Jane's section enforces, and that's called the Tenant Receivership Act. And that is a statute that is specifically focused on landlords that are engaged in a pattern and practice of violating the housing code. I sit in the Office of Consumer Protection, and the statute that we enforce primarily is the Consumer Protection Procedures Act. The Consumer Protection Procedures Act applies to businesses and protects consumers. The reason I'm here is because the consumer protection law in the district covers tenants. When you, as a tenant, rent an apartment, you're engaging in a commercial transaction with your landlord. Your landlord is a business, you're a consumer in that situation as well. So we can also apply the Consumer Protection Procedures Act in the landlord-tenant situation. This is kind of a new thing. The Consumer Protection Act has been around. It was one of the first acts passed after Home Rule in 1973. And when it was originally passed, it had an exemption in it that said that at the time, this was obviously before OAG, Office of Corporation Counsel was around. Corporation Counsel didn't even have enforcement authority. DCRA was the sole government entity that enforced the Consumer Protection Procedures Act back when it was passed in the 70s. There was an exemption that says DCRA could not apply the CPPA to the landlord-tenant context. That exemption, so OAG's enforcement authority gets added in the 90s to, at that time, Corporation Counsel gets added as an enforcing party. And just a little CPPA history here for everyone. It was unclear, the exemption was still in there that says DCRA can't apply it. Well, does that mean the Office of Corporation Counsel, which is not DCRA, are they bound by that exemption? Well, we had some legislation passed last year that clarifies that the landlord-tenant exemption does not apply to OAG. That law has now been clarified. So that's why Jane and I are both here. Now, one question Dennis asked is there sort of a key word in this area? Jane and I are both civil prosecutors, and the key word the phrase that we're looking at in terms of when would we bring a lawsuit against a landlord is a pattern and practice. So when there is a pattern and practice of violating the housing code or in engaging in activities that lead that are unsafe for tenants, that's when Jane starts thinking about this is a situation where she wants to apply and enforce the Tenant Receivership Act. And the same thing, that's what we think of on the consumer side when we see a pattern and practice of violations of consumers' rights. That's when we start thinking about bringing in an enforcement action.
And if I can just jump in and add to that, I know we have some questions, but the history that Jimmy gave you with the addition of consumer claims to these cases is very important because the receivership claim, the receivership action is only forward-looking. The goal is the court appoints somebody who will do what the landlord hasn't done, which is make a good faith assessment of everything that's wrong in this building and get some contractor estimates and start fixing these problems. So that fixes things for the tenants who are still there in these properties going forward. But of course, a lot of people have left because of the conditions. You might hear the phrase constructive eviction. They might have decided, I can't live this way anymore physically, and they've left. The consumer claims allow us to also get restitution for the people who have been living in the conditions all of this time, and to say to the landlord, you have to give them back their rent because you sold them a lemon, to use the car analogy. The car was no good. The apartment was no good. You were charging them rent for something that wasn't worth anything. So the consumer claims are very important because even if we get the landlord to start paying for the repairs that needed to be made all this time through the receiver, they've still managed to profit, in a sense, from all the years where they were saving money by not doing what they were supposed to do under the law. And that is, unfortunately, sadly, some people's business model. Like many people who don't comply with the law, their business model is to save money by non-compliance, to make money off of the backs of their tenants by not giving them decent habitable housing, on the belief that the tenants are not going to be able to assert their rights to housing and they're not going to be able to get help. So the consumer claims are a very key part of this. So the landlords who are held accountable under tenant receivership cannot say, well, it was still worth it for me to run my apartment the way I did all those years. Even if they came and got me now in 2017, I still saved all that money by not replacing the roof and the boiler all those years. So that's why the consumer claims are really key for deterrence in these cases.
Okay, Jimmy, I'm again looking at the computer screen over my left shoulder. It says refunding rental payments for substandard apartments. And it wasn't on my little cheat sheet here, but how does that compare to what is done at OAH?
So are you asking how does the
Yes.
measure of damages
Yes,
compare? Yep. So this is a really good question because we are new to applying the Consumer Protection Act in the landlord-tenant area. We have 2 cases that are in active litigation where we have consumer claims. We haven't actually got to the point yet where we're asking a court to set the restitution amount. So what we would, I've looked at the OAH decisions on that, and that is definitely going to guide us. I think the restitution we'd be looking for would likely be a very similar model to what OTA and tenants are advocating for rent disgorgement cases, for rent rebate cases in OAH. So we would be looking at some type of percentage. These are when we get to the damages phases of cases, these are going to be very fact intensive, and it's going to require lots of tenant testimony to come forward and testify about what were the exact conditions. So I'll tell you something as a prosecutor, what we try to do just to make the case proceed better is we try to come up with a framework for rent rebate payments that can be applied against a class, because we are, in civil enforcement cases, they're very similar to a class action. We're representing and trying to get restitution back to all of the affected tenants. So we would try to look for categories to try and do that, but it should be a very similar analysis.
Okay. Now, if you'll all forgive me, I just want to talk a little bit up here. You can listen in if you want to. At OAH, of course, they will establish that an apartment or in a building, if there are multiple tenants that are involved, have, I'll use the word suffered through certain housing code violations. The judge will assess a value to that housing code violation, then ask, how long has this been going on? Okay, and then they do math. 6 months at $75 a month, and you're going to get out to, oh my gosh, I picked the bad numbers. We'll call it $450 judgment. Now, is that somewhat like what happens in your cases, or do you have a different way that it's gone about?
So that is the analysis we would have to do in order to calculate restitution. So, what happens often in an individual tenant's rent rebate cases, the administrative law judge at OAH sets a value somewhat based on past precedent, but somewhat is the ALJ, I think, picking a number of, okay, here are the issues. You had a broken door, you had broken windows, the heat was off, and the judge has to assign a value for how much of the rent that, a real dollar value. So how much back every month should you get that you didn't have air conditioning? And then, as you say, multiply it out. What becomes difficult in a government enforcement case is we've got to do that. We might have a property where there are 80, 100, 200 tenants, and so we've got to, trying to do that type of individual analysis for all those entities is very time intensive. And so what we try to do is come up with categories and to make arguments about, at a minimum, how much rent should be paid back. So let's say, for instance, let's say you have a situation like Terrace Manor, where you just have a whole host of endemic housing code violations that have gone on forever. One way that you might try to value how much rent should be there is to say something like, well, look, this particular entity really didn't do anything except provide walls and a leaky roof, so they ought to substantially be paying back most of the rent. So as a government in a civil case, we want to try to categorize restitution in a way like that, so that we don't get stuck with a 4, 6, 8 week trial where we have to bring in every affected tenant.
Well, are there civil fines that go into your cases, or just restitution?
No, we can recover penalties as well.
Okay. Mr. Gamboa, I feel like I'm ignoring you over there, and I don't want to do that.
Okay. Thank you for,
Well, okay. Now, everyone in this room, in their mind, knows what a slumlord situation is, even if it's not a legal term.
mm-hmm.
And I suspect you have some idea of what a slumlord situation is like. You're out in properties every day, and I'm just trying to establish that we have a significant reason for this panel. So, in your experience, how many slumlord situations do you think we have in the district right now?
Based on my experience, I have encountered many of the so-called, even though it's not official or legal term, slumlords in the district. Maybe 100 of them exist in the city. Slumlords on my definition, is a slumlord that doesn't maintain or upkeep the unit that being rented out. So even also if they've been paying attention to the unit, they only do the minimum. Sometimes it drag their feet to make some repairs, and it takes forever for them to complete or abate the code violations to the expense of the tenants. That's my definition and the number of slumlords that I know in the district.
Okay, now for my OAG pair here, if we've got a particularly bad case, I won't use any property specifically, we'll call it House of Representative Heights. Are both of your sections involved in this? Or is one of you say, I'll take this one, I'll take this one? How does that work?
So the Housing and Community Justice section is the section that is charged with bringing the housing cases and taking care of the housing side of these cases. Mr. Rock's section has many, many consumer cases, not only the housing ones, and they have been defending the rights of district consumers for quite a long time. But we do work with the consumer section in terms of intake on a case because, as you heard from him, it takes a lot of capacity, especially in determining the damages amounts for the tenants. So anytime we are getting information from our community partners about a potential tenant receivership case, we're also talking to the consumer section about what is your capacity to handle the consumer side of these claims, because we want to make sure there is deterrence for landlords both going forwards and going backwards. So Housing and Community Justice has, I think I should say now, we have 4 full-time attorneys who work on these housing matters, and we have currently several investigations that are ongoing into properties, as well as 3 cases that are in active litigation. You heard from the Attorney General that we're going to be expanding our efforts in this area, and we certainly will be doing that to the extent that these 4 attorneys and I are able to do that. So we're going to take on as many cases as we have capacity to take on. But at some point in this presentation, I'd also like to go through with this group the structure of a Tenant Receivership Act case and how we build one of those cases, because it is provided in the statute that tenant groups can also bring these receivership petitions before the Superior Court. We want to take on, with our resources, as much as we can, but I want to be clear that tenants groups, community advocates groups, your hands aren't tied. You're not on a waiting list for the OAG to get relief through a receiver under this statute.
Well, Jimmy, we know that there's a problem. Mr. Gamboa has made that very clear. A lot of slumlord type properties out there. We also know the Office of Attorney General, as wonderful as it is, just doesn't have the resources to go in everywhere. You have to do some triaging. How do you triage your cases?
So on the, and maybe this is a better question for Jane to respond to talk about how they triage the housing and community justice side. I can just tell you briefly on the consumer side, what we're looking for is a situation where there is continuing to be active consumer harm to a large number of district consumers, and that's where we then want to focus our enforcement authority. I think Jane is probably better able to speak about in the specific in the housing context, how that triage is done.
Absolutely, happy to speak to that. So right now, one of the most important sources of intake for our cases is the community and the community partners we work with. We're the attorneys in the offices, but it's the tenants who are living through these conditions and their representatives through their own organizations and through community advocacy organizations and churches that know what's going on out there, and they are the groups that bring these situations to us and say, can you help us? So that's a big intake source, and when a community is telling us that something is a priority, that's certainly a factor. But as Jimmy said, with our limited resources, we're looking for high impact cases. So as you may know, with the Sanford cases, there is an owner who owns not just one, but multiple, a dozen buildings in the district. And another thing we would look for in a case is these are all low-income tenants, many of whom are receiving subsidies, and the tenants and the subsidies they receive are harmed by this kind of pattern and practice that we see, because a landlord doesn't necessarily have to evict people under the district's very tenant protective laws. If they simply mismanage the building enough, the subsidy granting agencies might be forced to say that the conditions in the apartment are no longer sufficient to maintain that subsidy. So when we're looking at cases, one thing we're looking for is, are a lot of people affected by this? Are they particularly vulnerable? Is this affecting people who are receiving subsidies? Is the high impact cases are the ones that the Office of the Attorney General wants to take, because we have the most, I think, heft behind our enforcement powers, including, in theory, criminal prosecution. It has not come to that point with any landlords thus far, but I think that's always something that a defendant would consider when they are on the other side of the prosecutor's office in court.
Well, I'm going to do a very dangerous thing for an attorney. Ask a question that I don't really know the answer to in advance. Does DCRA play a role in your deciding what cases to take, Jane?
Well, certainly if certainly DCRA and is the instrument by which we build our cases. Like I said, as the tenants and the tenants associations, the advocates are out there pounding the pavement, so is DCRA. They are the ones who will go out and document conditions in the apartments and come and re-inspect those conditions. And when a prosecutor's office is before a judge, although of course we can present witness evidence from tenants, and we always will do that, there is an expectation by the courts that we will be presenting agency witnesses as well, and official agency enforcement documentation. So anytime the prosecutor's office is in court, if there is an agency charged with enforcement in that arena, the court is going to expect us to have that as part of our case. So DCRA is crucial in building our cases, and DCRA, like any other agency, can come to the Office of the Attorney General and say, this case is a priority. We think in all the cases that we've seen, this is one where a receivership solution is needed. And that is essentially, I think, how DCRA would influence our cases. We already have some cases that are non-receivership cases, which I can't talk about extensively because they're in an investigative phase, where DCRA has said, our toolbox has not been sufficient to get this landlord to comply, and we would like you to take them into superior court. So we are already doing some of that work with DCRA, which I think is relatively new in terms of landlords who have said explicitly to the inspectors, I'm not going to do anything else. You can cite me all you want. I am not going to lift a finger to fix this building. Well, DCRA could come to us and say, let's see if they feel that way after you take them into superior court. So we're trying to build a closer working relationship. DCRA is an agency that has a huge responsibility and a very lean staff in which to carry out that responsibility. So as we work closely with the agency, we try to make sure not to be stereotypical lawyers and take away a lot of the time that the inspectors need to spend out there on their daily responsibilities, gathering documents for us or doing tasks that may or may not result in litigation. So that's an ongoing, I think, project and a relationship that we're building with them.
So Jane, would you consider it an oversimplification to say that DCRA is essentially the investigatory arm in your cases?
I would say that they're about half of the cases. I think this is a good time for me actually to run through, if I may, some of the slides I prepared to show how we build a case, because this will really, and forgive the rewinding through the slides, but I think this is something that it's important to understand for everyone who's interested in these cases. So as we mentioned already, the Tenant Receivership Act is used in situations where there are risks to life, health, and safety. There are two grounds on which a receiver can be appointed. One of them is that DCRA has issued a violation notice for a life, health, and safety issue, and the owner has not abated it in the required time. So examples of that we see often are fire suppression equipment is broken or defective. Sometimes in buildings, people have ripped out the copper piping that goes to the sprinklers, and the landlord has not bothered to replace it because it's quite an expensive repair. Lack of heat or hot water or lack of air conditioning in the winter are also some of the serious violations that the DC inspectors find. And our evidence for that is going to be the inspector's initial inspection report and the notices of violation they issue, plus when they come back after the allotted time to repair, the inspector's report and the notice of infraction that they issue saying, I gave you so many days to fix this hot water issue, and I came back when you were supposed to have fixed it and it was still broken. So that is what we need to present to the court if we are pursuing a receivership appointment on the first of these two grounds. And I'll say often in these cases we're using both. But there's also a part that does not involve DCRA at all. The second ground for appointment is that the owner's neglect has caused these life, health, and safety risks, and they have been present for longer than 30 days. The council included this because it's very important to recognize that in some buildings, people might never have called DCRA. They might not have felt that that is going to be the right solution for them for whatever reason. And so this prong is to make sure that the statute covers these buildings where these things have been going on and the tenants have been telling their landlord and nothing is happening. And we don't want to hamstring tenants and say that they have to go about getting relief in one prescribed way through the agency in order for the statute to apply. And some of the things we see under this are very important because DCRA does not have the ability or authority to cite for these things. Mold is an important one. When your building envelope is compromised, the roof is leaking, the walls are porous, water gets in, mold grows because mold spores are everywhere. The only thing they lack is a water source, but when they're given a water source, it's going to grow. There is a DC mold statute that requires trained experts to come in and identify where there is mold. DCRA right now has very good inspectors, but they don't have the certifications to identify mold, nor does any code enforcement in the country have the authority to order a landlord to do something like rip down drywall to prove that there's no mold behind the walls. You just cannot force an owner to open up their walls in that way. So a landlord can come in, scrape the mold off a wall, throw up a coat of paint over it prior to an inspection, and that mold and the water is all sitting there behind the wall. But the inspector, in the full extent of their authority, has to say, well, I see a dry, clean wall, and I have to say that it's not there. So it's very important that we get at issues like this through tenant testimony. Holes in the roof or leaks. You can have water infiltrating a building and be damaging things behind the scenes. And again, the inspectors can't say, well, I don't see any outward signs of this problem, but I'm going to make you open up the walls and strip it down to the studs to prove it to me that you don't have water. They don't have the authority to do that. No code enforcement officers that I'm aware of in the country have authority to do that. But tenant testimony about the kind of ongoing problems you see as a result of that chronic infiltration are crucial to help us build that case, as well as construction experts who can come and look at a building and say, I can see that water's going to come in through those bricks, this drainage system's not set up properly, all the signs are there. Vermin infestation, similarly, you can have an exterminator come to the building on Monday and your inspection is on Tuesday, and all of the rats and mites and roaches and water bugs might be gone for the next 42 hours. And the inspector can only say, I was there on this day and I didn't see any of these things. But the tenants we talk to say, sure, but they're all back again on Wednesday and Thursday. So things like that, we really need the eyewitness testimony of the tenants in the buildings to say, look, they papered over this just in time for the inspectors to come in. But the fact is, these infestations have never gone away. And the evidence for that is all going to come from tenant affidavits and documentation that the tenants provide, which is why I should add it's been so excellent for us to work with tenants who are organized or who have counsel. Now, of course, that doesn't mean we won't work with tenants who aren't organized, but we want to be clear that we're bringing these actions in support of and in conjunction with tenant organizers and groups who want to assert their rights themselves. So it's not an either-or proposition, either do it through your own group or do it with us. We're working hand in hand, and we want to other tenants to see, hey, those folks got organized and they were able to assert themselves and get decent housing, and maybe we should do the same thing too. So building our cases has these two sides to it. When we hear about a building, we're going to review the existing records that DCRA has already created on that, because it's very rare that they've never been to one of these buildings. And we're also going to talk to the Tenants Association, or if there isn't one, we work through the tenant organizers who know these communities and who've been there to go out there and talk to the tenants. Because, you know, nobody necessarily wants someone from the Attorney General's office just popping by their apartment to ask them a bunch of questions. We want to make sure that that the tenants are talking to people that they trust, who are only going to convey whatever information the tenants feel comfortable conveying to us. So often we have tenant organizers go out to the properties and talk to the tenants about conditions and gauge their interest in working with us on one of these cases. And the second thing to do is, if there is a core group of tenants who are interested in pursuing this action, to coordinate them for a property-wide inspection by DCRA. Because what we really want to do in these cases is get a comprehensive look at the building. Because these cases aren't about getting a checklist of things the landlord needs to fix and then getting them to fix those things. This case is about saying, this landlord is not responsible, they are not taking care of their property, and they should not have the job of doing that anymore. The court should appoint someone else to do it. So the more we can get DCRA inspectors access to the units in these apartments to document everything that's going on, the better. That means the tenants either have to be home on the day that all the inspectors come, or they have to find someone they trust and sign over the right to let that person give the inspector access to their apartment. Because DCRA is only as effective as the amount of access they have. They can't cite people for things that they can't see behind a locked door. So we get as many of the tenants coordinated as we can, and with DCRA, schedule a property-wide inspection on a day that's most convenient. Obviously, most working people, me included, cannot just randomly be home on a weekday. So it's very important to give people a lot of advance notice and have them find a tenant advocate or a friend or a neighbor who can be home, who they can give permission to access their apartment. And after that property-wide inspection, our first question for DCRA is, did you find life, health, and safety violations? Because these cases aren't just based on a loose doorknob. They have to be things that really affect the life, health, and safety and security of the tenants. And then step 3 is, after the notices of violations have been issued for whatever was found, we talk to the tenants and we start to get their statements and put them in the form of affidavits and anything that they have documented. And typically, DCRA will come back for a 1-day and also a 30-day follow-up inspection after the property-wide. And whatever isn't fixed at that time, that's a life, health, and safety violation, those are our points that we are bringing before the court to say, we told them the fire extinguishers were broken. Came back after a month, they weren't fixed. We told them this was broken, this wasn't fixed. Sometimes the landlords manage to fix 1 or 2 easy things, but some of the more serious things, nothing's happened. And that is the way we build a case. So it definitely requires not just one or the other side, but coordination between the tenants and the DCRA inspectors to make sure we get as much evidence as possible to show, as Jimmy said, that there's a pattern and practice of neglect at these properties, that all these things the landlord should know about and should be making an effort to fix have just been allowed to go on with no remedy.
Okay, Mr. Gamboa, she said property-wide inspections. Now, I remember the old days when there were property-wide inspections. Are there still property-wide inspections?
We call them now building-wide or proactive. Building-wide is to inspect the entire building. Proactive, we inspect certain percentage of the units in the building. So what we do, instead of inspecting 1 unit in the building, we inspect all of the units and perform the process of inspection, go out on the site, meet the tenant, and determine if there's a housing code violations in the unit. And once we determine there's a housing code violations, we cite the landlord, prepare the notice of violations, and we mail it to the landlord, provide a copy to the tenant, and then we give a time for the landlord to abate the problem. Basically, Ms. Jane lay out all the DCRA process actually. But we give them time to abate the problem, and if they don't abate the problem, they don't fix or abate the code violations, we prefer the notice of infraction. This notice of infraction, we refer to the Office of the Civil Infraction or Enforcement Division, where in turns we may fine the landlord and at the same time abate the code violations.
Well, Mr. Campbell, I'm still a little bit unclear. How do you determine whether you're going to inspect every unit or a percentage of the units, depending on the building size?
Okay, there were, like what I mentioned before, there were two types, the building-wide and the proactive. Building-wide is there are several or multiple complaints in a building. Primarily, the housing inspection program is a complaint base, meaning we take complaints from an individual tenants or any entity, the mayor's office or the advisory neighborhood commissions. Compared to building-wide, when we receive multiple complaints in a building, we'll make a decision that we will perform a building-wide, meaning we will inspect the entire building because of multiple complaints at one time in a building. The proactive is different because we randomly select a property every month and we perform an inspection, a certain percentage of the units in the building.
A property.
A property, yes.
Okay. Now, let's suppose that you have selected a property. This is the September proactive inspection.
Mhm.
How many units are you going to go into?
It depends. If the building has 3 or 4 units, about 50%. If the building has 9 or 10, 40%. If the building has 15 to 20, it becomes smaller percentage, 30%. So it depends on how many units in the building. The lesser, the bigger the percentage. The more the units are, the smaller the percentage.
Okay, and just a moment. Okay, so who decides what units you go into?
It's a random selection. Also, with proactive, we post the building 2 weeks in advance. We provide them the date and the time of our inspections, and then we encourage the tenant to call us in advance so that we know any units or any tenant that requires or an immediate inspections. And if we receive those multiple lists, then we will inspect those units plus the percentage of the units in the building.
So you're saying that the tenants get notice that you're going to be in. They probably get notice that we will be in this unit. They'll get notice we're not going to be in this unit. But if the tenant of this unit says, dang, I want them to do my unit too,
Correct.
they have an opportunity.
Correct.
And how do they take advantage of that opportunity? How do you know about it?
They take the advantage when they see the posting in the building, and once we take those complaints or names of the units or the tenants, we respond to those units and we cite the landlords if we found or discovered some housing code violations.
Do you ever cite tenants?
Unfortunately, the violation is not only for landlords but for tenants too. If the tenants intentionally destroyed or broke anything in the unit, then they are responsible, and we will also cite them.
Okay, now Jimmy, we've gotten pretty good idea here of how Jane's section coordinates with the DCRA. Does your section have a relationship with DCRA as well?
We do. We do on a variety of issues. We have been focusing over the past 18 months on housing issues. So for instance, we brought a case against a husband and wife home flippers who were operating in the district, who were renovating and selling homes. And we worked very closely with DCRA on that case because it was the same sort of thing. DCRA is the line administrative enforcer for things like the housing code and the building code. So to the extent that in the Office of Consumer Protection, we're bringing a consumer case that touches on an area in which DCRA is the line administrative enforcer, then we work closely with DCRA to gather our evidence for that. Yeah. I just want to give an example that I think was coming to mind as I was listening to this conversation about the importance of tenant testimony, because I think sometimes we don't give DCRA enough credit for the ways in which landlords frustrate DCRA's oversight. So we have a pending case. I just wanted to describe an email from this pending case, which is not the subject to a confidentiality order, that just gives you a sense for what landlords do. So this is one where there was there had been an initial round of DCRA inspections that had led to notices of violation, and DCRA was preparing to come back out and to do a reinspection. And the management company for this particular large apartment complex, was writing emails internally among themselves the weekend before the DCRA reinspection was to occur. And they were talking to themselves about what they were going to do to prepare the building for this. And they were talking about the fact that they were going to contact a paint company that they worked with and have them do a quote coat and go in order, and this was in quotes, in order to cover up what was an obvious mold problem. And there's all of this email communication going back and forth over the weekend as the landlord's getting ready for DCRA to come out and do the reinspection. And so we know from evidence like that the landlords, will work to put in cosmetic repairs in order to frustrate DCRA's ability to see that the issues are ongoing when they come back out to do the re-inspections. And that's one of the reasons that the tenant testimony is so important, because we need the tenants to fill in those gaps. And that's what has been so helpful on the consumer side of these cases, when we have the tenants and the tenant organizers who are constantly doing things like just taking pictures so that you can fill in the gaps, because the landlords want to. And these are, not all landlords are bad, but the problematic landlords, so they're going to take steps like that to frustrate DCRA's oversight ability, and they're going to make the building look as cosmetically as good as they can for the reinspection. The same sort of thing we were seeing in the housing cases when we were doing the home flipping, when we were doing some of our home flipping cases. They would cover up, the builders would go out and they would cover up things when DCRA was prepared to come out and do the building and the construction inspection, so that things would look okay. But then then they would immediately rip back open the walls, and there would be all the stuff in there that now the DCRA couldn't see when they would come out to do the inspection. So it's really important to have that tenant and the tenant organizer testimony to fill those gaps in of what does the building really look like when the landlord isn't scurrying around in the 48 or 72 hours before DCRA inspections.
I have a story to add. I just heard a particularly egregious example of that. An elderly tenant living without air conditioning in their unit the day DCRA came to inspect. 2 maintenance people came and installed a window unit in her apartment, and after the inspector left, they came and took it out again. Which, really just goes to show how sort of deeply committed some of these owners are to their cruel conduct. You already had the unit in there and installed, that they're really going out of their way to undo some of the good steps that they take just to get over with the inspectors.
Well, Jimmy, I'm really curious about the coat and go emails. Are you going to tell me that housing provider went over to 441 with a stack of emails and said, "Mr. Rock, I bet you'd really like to see these"?
No, these were emails that we forced the company to produce. So, that's one of the good things about being the government and the consumer protection area. We have pre-suit discovery powers. So before when we sue a company or we sue a landlord, and we're in litigation, we can demand that they produce documents to us. And the government on the investigative side, we don't have to wait until we file a lawsuit. We can send subpoenas before we file a lawsuit as part of an investigation, and we can force the company to give those to us. And that's not a power that DCRA has. They can go out and they can inspect, but in order to compel, something like having the landlord turn over its emails so that they would know about that. DCRA can't say, okay, give me all of your emails from the last 72 hours, management company, so I can see what you've been doing to prepare for this investigation. But at OAG, we have authority under the CPPA. And I don't know, Jane, do you have any pre-suit investigate powers in the Tenant Receivership Act?
No, not under the Tenant Receivership Act, although I do want to note another area we work in, wage theft. We do have pre-suit investigation powers. So if people report to us this employer is stealing wages, but none of the employees can come forward, we can subpoena them and ask for a lot of information about their payroll records. And if they don't have those records, we can fine them for failing to keep them, as they are required to do under the law.
Okay, ma'am, you've been waiting patiently. This is a good time. What is your question?
Two questions, and they're questions and not comments. Questions, and then I'll add comment to it. Who's
Now, see, we're taping these sessions to be broadcast on the internet, so we need you to speak into the microphone so the world will be able to hear you.
You are all a meme now.
Whose task is it to enforce the abatement process? Our experiences on the ground in real life and not in your offices is a homeowner under a voucher system or providers in public housing or in scattered site or tenant-based housing. Action comes, the tenant reports a challenge to life, health, or safety. Inspectors come in, give that property manager or that owner a day or 30 days to abate. Day 31, it hasn't been done. The renters are asking, where's the guy, what's going on, what do I do, whose job in the agency is it to make this person abate? People have waited uncommonly long periods of time, 2 to 3 weeks, waiting for somebody to enforce the abatement. Sometimes it never gets done. Second thing is, what happens with mold? I'm hearing you all say there are mold enforcement police, but on the ground we know folks whose houses are mold or who have mold, and it's the runaround that we don't have a certified mold inspector. We have a mold inspector. We can't prove mold, so I got to live in a mold till I prove the mold. Those are my two questions: mold and who enforces abatement.
Okay, let's go with your first question first, because what I'm really hearing is the breakdown is subsidized housing versus non-subsidized housing. And who does the inspection? Who does the enforcement activity? Mr. Gamboa, would you like to have a crack at that one?
Yes, thank you. Thank you for your question, ma'am. Regarding your question, whose task is to enforce the code violations? My response to that is DCRA, once we receive the complaint, we respond to the site and determine if there's a code violations. Once we determine there's existing code violations in the unit or in the building, we prepare the notice of violations and we mail it to the landlord and a copy to the tenant. So like what you mentioned, we provide them a time to abate the problems. And on day 31st, and they have not abated the code violations, we prefer the notice of infraction. We refer to the enforcement division, and they prefer to fine the landlord or the housing provider. At the same time, they still have to abate the code violations. And still it didn't work with the OCI or the civil infraction. We could either refer it to the Office of the Administrative Hearing, or we can also seek partnership with the Office of the Attorney General.
Okay, Mr. Gamboa, is there we'll call it a division of labor between your inspectors and the housing authority's inspectors?
My understanding, if it's under a subsidiary or Section 8 voucher, we still perform inspection if a tenant is a Section 8 or they call it subsidiary voucher holder. We still perform the inspection on that unit. But if in terms of prosecuting the landlord, we prosecute them, and DC Housing also prosecute them. I don't know their process, but in our process, I just mentioned to you, we'll give them time to abate, and if they don't abate it, we refer to the civil infraction or to the OAH, or we get partnership from the Attorney General.
So, Mr. Gamboa, if this lady were to call DCRA, and we'll talk a little bit later about exactly how to do that, and she says, I've got this problem, and by the way, I've got a housing choice voucher, but I still want you to be out and inspect it. What does your scheduler do?
Once we take the complaint, we schedule an inspection. Once we talk to the tenant or the Section 8 voucher, we provide them a 2 hours window, and then we come to the site and perform a thorough inspections. And we'll go from there. If we find code violations, we cite the landlord.
So you do that regardless of who the landlord is?
Yes.
I want to make clear, though, we're not just talking about vouchers, we're talking about market rate people as well. And I submit that there is a breakdown from the time that you give them a period to abate to your enforcement around that
Okay.
abatement.
Let-
Tenants have
let me-
waited a long
I
time.
think I can help you with that. Mr. Gamboa, let's go a hypothetical example. We lawyers love hypothetical examples. Let's say that you go out to something property and you say, oh my God, there's a violation here. The landlord has 14 days to get this fixed. When is DCRA going to be in the property the next time?
So either we get a complaint from a housing voucher holder or a market-based renter. We perform either one of them. And once we determine an existing code violations, there are two types of code violation. One is a life safety issue, and the second one is a routine maintenance. What's a life safety issue? Life safety issue means it will affect the tenant or the occupants. Let's say, for example, the smoke detector is not operational or is missing. That's a life safety. Or there's a sewer backup. That's also life safety. Those are normally 1 to 5 days. We come back 1 to 5 days. If it's really critical, we come back 1 day. We even shut down those units that are critical. Sewage backup, that's number one. We have partnership with the Office of the Tenant Advocate, with different agency. Sometimes we even call MPD, and a couple of the MPD are here in the boardroom. They help us to shut down the unit and provide accommodation to the tenants right away, immediately, with the help of the Office of the Tenant Advocate. And then there's also the routine maintenance, where just peeling paint, not significant, just minor peeling paint, a broken handle, a hole on the wall, just a small hole. Those are called routine maintenance, and we give them, the landlords, 30 days to abate those problems. So critical issue is our life safety and routine maintenance.
And I'm going to speak
Go ahead.
quickly. I'm going to speak quickly to answer your mold question, and then I want to make sure we have time for the other questions. But just to answer that, there are no mold police, unfortunately. The mold law puts as it exists now, puts the burden on the tenants to report the existence of mold to their landlord, and then once that is reported under the law, the landlord is required to do certain things. So. And including, in some cases, if there's over 10 square feet of mold, hiring a professional mold remediator to come and remediate that mold. There is a standard. Landlords can always come in and say, oh, well, I looked and I didn't see any mold, but you want to have the pictures to back that up. It's not a perfect solution for people. If you know that you have mold, but the landlord has an expert come in and says they didn't see mold, or they tested for it and they didn't find under their air quality test that it was mold, that it was just mildew, then they're not obligated to do anything further, and you might have to go to court as the next step to enforce that law. But the bottom line is, I just want to be clear, there's no mold police, and it's very difficult to get landlords to get the mold remediators to come in because they are enormously expensive to do it. They charge hundreds of dollars an hour plus lab tests. So that's a strong financial disincentive for people to get the mold inspector in. but the Office of the Tenant Advocate, I believe, and other tenant advocate groups are interested in this law and do provide very good advice to tenants seeking to enforce their rights under the mold law.
Well, thank you for noticing. Okay, next question.
All right, so I have a question for everyone. So I'm going to start with you, Mr. Gamboa. You mentioned earlier that once an inspection is done by DCRA, there should be a building-wide inspection. Once that's done, there should be a report that's sent to the landlord as well as the tenant. Will it be, so the question to that is, will it be sent to all of the tenants, or is it sent to the landlord in hopes that he distributes the results of the inspection to the tenants?
Thank you for your question. Your question is, after we perform building-wide, do we send the report to the tenants or all of the tenants and to the landlord? My response to that is, after we conduct an inspection, we prepare the notice of violation and mail it to the landlord and provide copy to all of the tenants. Any unit that we can perform inspections, they also obtain a copy of the notice of violation.
Well, let me pin you down on that just a little bit, if I may. Let's say Monday morning, you go out to her unit, and your inspector does something. When is the tenant going to know what the results of that inspection were?
Normally, when there's a 1 day or 30 days, we mail the notice of violation within 5 days, because unfortunately we don't control the post office, but we provide at least 5 days of mailing time.
To whom?
So eventually, within 5 days or 7 days, you will receive a copy of the notice of violations. However, if you don't get a copy, then you can always call DCRA, and we will provide you by email or send it again, the copy of the notice of violation.
So exactly where should they call? There may be some people want to know this.
They can call 202-442-9557, option 6. Option 6, you will talk to a live person and ask for the housing inspection program. Then you can ask for me or the admin person.
And, okay, you ask for you or the other person. And what do you say? Is it more or less say, you were out here, there was an inspection, I have not received an inspection report, please send it to me. Is that the gist of it?
That's correct. We will take your address, your name, if you have an email address, and we will email to you or mail it again.
In the rare cases that doesn't seem to be effective, feel free to call us at Office of Tenant Advocate, and we will make the call as well. And sometimes that accentuates the request. Okay, Barbara, did I see you with your hand up earlier?
Oh, no, I'm sorry. I had two more
Oh.
questions. One for her and one for him. So Jane, you mentioned that a follow-up inspection will be made after follow-up inspection made by DCRA after an inspector comes out and the landlord remediates whatever the issues is, and an inspector should be coming out, right? Who calls for that inspector? Does the tenant call for the re-inspection to make sure that the landlord actually fixed the issues, or is it something that your office automatically does in regards to ensuring that all of the problems have been fixed?
Well, let me first clarify what I was talking about and what's on this slide here is our office process when we have started an investigation into a property where we think it's appropriate for Tenant Receivership Act. And these Tenant Receivership Act cases are ones where the neglect has been ongoing. There have been tons of violations that haven't gotten fixed. They may or may not have been part of the normal enforcement process. But what we're doing is and like I said, we've had this limited number of cases. What we're doing and what I'm speaking to is when the Office of the Attorney General is actively engaged in a joint investigation with DCRA. So in those cases, when we call DCRA for that initial property-wide inspection and try and get the tenants all ready for that, it's understood that there's going to be an initial inspection and a follow-up inspection, and we work with them. We're in almost constant communication in these joint investigations and building a case to say, okay, you went out for the property-wide inspection on this day. We've talked to the tenants. We'd like you to come back on day 31. Obviously, we want to get it done as quickly as possible in order to gather the evidence that's there for our cases. So in our investigation cases, the inspectors are typically going out very close to 30 days after, and they're often making multiple trips back out to the property because despite our best efforts, sometimes they aren't able to get into certain units. And the attorneys are with them on those inspections as well. So I've gone out, all my attorneys have gone out for these initial property-wide inspections and the follow-up ones. But to speak a little bit to the question we heard before, too, there is just a normal property inspection process that involves complaint-based inspections as well as proactive inspections, which are like surprise audits for the owners. And like I said, DCRA has a very lean staff, and they have a certain toolbox for enforcement that involves going out and then coming back when they can and issuing fines. And, what I've heard from this group and from other sources too is that when the follow-up is not happening on the expected timeline, when the fines aren't effective, it seems that you run up against the limitations of enforcement, and that for the landlords, there's some people who do comply. They get the notice and they comply. They go and fix it. Some people ignore the notice, but when they get the fine, they comply. But there's this whole area of people where they're ignoring the fines, they're ignoring the re-inspections, and we know that there's 100 or so slumlord properties out there, and it's a very difficult task we have, and that is something that needs to be addressed with our enforcement processes. So these tenant receivership cases are sort of the tip of the iceberg, the worst of the worst cases that come to us, where we address them where things have been ongoing. But there, I think, is a separate issue to talk about, not for this panel, about what do we do with that whole bunch of landlords where it's not necessarily a slumlord case, but we also know that they're not complying with enforcement, and that is also something of concern to both of our offices.
And last but not least, it's actually a double question for you, Mr. Rock. First is, are there any statutes of limitations as far as repairs that's been ongoing but has not been settled between the tenant and the landlord? And if so, what is that timeline of several tenants complaining about the same thing? It's not getting done, and how does your office kind of views what that timeline is?
So in terms of a statute of limitation, when we as the government are bringing a consumer case, there is not a statute of limitations on our claims. For private rights of action under the CPPA, there's a 3-year statute of limitations. Now, what you're describing are a tenant's claims against their landlord, and what is the statute of limitations, which would be carved out of the Consumer Act. I don't know what the statute of limitations would be on something like that. Dennis might know that, but it's probably 3 years. But,
Yeah, 3 years is kind of a standard, and I would also say that if there is the filing of an administrative action, such as what's called a tenant petition, there's a 3-year limitations period on that as well. Okay.
And, I'm sorry. Part B to that third question is,
Okay, I tell you, let me come back to you.
Okay.
I promise if we get, depending on what that clock behind you says, I will come back to you.
Okay.
But I wanted to ask, Jimmy, Jane, does the Office of Attorney General have any outreach programs for the tenant community? I'll let you have that one first.
So we have a general consumer complaint line, and you can reach us. If you go on OAG's website, oag.dc.gov, there is very prominently a link into our consumer complaint portal, which will allow you to send us a message through the website, or we have a phone number. It's up on this screen there, 442-9828. And that will be, we'll have a live investigator or ombudsman who answers that line, and we'll do a consumer intake. If it's a landlord and tenant related issue, we will refer that over to Jane's, to the Housing and Community Justice. So you can use that as a point of entry into our office if you have a landlord tenant complaint.
Jane, you anything to add?
Well, if you want to contact the Office of the Attorney General about a case that you think is appropriate for a receivership action, we don't have something like the consumer complaint hotline set up because there already is a very excellent tenant advocacy hotline run by the Office of the Tenant Advocate. And we are working closely with OTA to make sure that they are able to identify the cases that would be good candidates for receivership. So certainly tenants can call the OTA hotline. Since you guys are here in front of me now, I will tell you my email address is jane.lewis@dc.gov, jane.lewis@dc.gov. I will say I don't recommend that you distribute that email and tell people who are having a landlord-tenant issue to contact me along with all of the other tenant advocates, because what we do is so much narrower. And I know that it's difficult. There's already a large burden placed on tenants who already are living in difficult circumstances to go out and seek out the right source of help. And I don't want to add an extra name to people's checklists and add to their time burden when it's not likely that in most landlord-tenant disputes we will be the right avenue to help. I think the best way for us to get case referrals without putting an extra time burden on tenants is to go through the Office of the Tenant Advocate. And certainly when contacting OTA, it's helpful to mention, we think our building would be a good candidate for a receivership case.
Okay, it sounds like I'm summing up when I'm really not. But to sum up, consumer protection issues, 202-442-9828. For properties where you feel like your property is a candidate for a receiver action, probably the simplest way is to call our office at 202-719-6560. And you've got a problem. You're going to call the Department of Consumer Regulatory Affairs, that's where all the housing inspectors are found. You're going to call 202-442-9557. And then when you get stuck in the voice jail, you're going to immediately go down and push 6, which will get you to a live person. But now, since we're talking about 9557, option 6, Mr. Gambaugh, let's say one of these people calls that number, says, I've got a problem, I need an inspector. When are they likely to see an inspector in their unit?
Thank you, Mr. Taylor. I think this is the best time to show the what do we do, what DCI does. I mean, if I could.
I think these are just our slides.
Oh, sorry.
Okay,
I'm not sure if
are you the person who is able to switch from PowerPoint to PowerPoint?
Yes, I can do that.
I think this would be a good time.
Do you have my presentation?
I believe I have another presentation.
It's probably yours.
He has both presentations on the thumb drive. While this is in progress, it's time to give you a quick word from our sponsor, the Office of the Tenant Advocate. And the Office of Tenant Advocate would like to hear your impressions of this particular session. if we had a volunteer sitting here, I would have that volunteer now hand out some survey forms, little one page, one side English, one side Spanish. Pick ever one that you feel appropriate and just do a few 1 through 5 answers to questions. We don't have one of those. So while Mr. Gamboa is answering my question on housing inspections, I'm just going to go pass those out now. No, they're over there on that little table right there. Notice how he,
We have a volunteer, I think.
Well, I have a general question.
well, first things first, Mr. Gamboa needs to give his
Sure.
talk.
Where are the papers? Oh, you're counting.
So, okay, I will talk about housing code inspections under Department of Consumer and Regulatory Affairs, or simply DCRA. Who are we and what we do? We are the inspection division of the agency. There are about 6 departments. One is vacant or blighted property. We respond to the vacant property and cite the owner or the property owner if they're neglecting the vacant property, like overgrowth, vegetation, or the existing house that's not properly maintained. And then we have the housing code inspection, which is under me. We primarily respond to housing complaints from tenants, mayor's office, or the ANC commissioners. And then we have the proactive inspections that randomly select a property every month and perform a percentage of the unit in the building. And then we have the new and illegal construction that respond to new construction, and also new construction that are performing illegally, meaning they have no permits or working beyond the scope of the permit. And then there's a third party. These are inspectors that are independent. We have about 80 independent third-party agencies in the city. Other than DCRA, they also perform new construction inspections. And then the last and not but the least, we also inspect the elevators and boilers in the city. Currently, I have about 14 inspections in the city and 1 housing inspection program manager, which is me. What is the housing inspection process? So, like we mentioned a while ago, we respond to complaints from tenants, from the mayor's office, from the NC commissioners. We take their complaints, we respond to the site, and when we determine there's a housing code violation, we cite either the tenant or the landlord and mail the notice of violation to the landlord and provide a copy to the tenants. We give a certain time or time to abate the code violation. When the landlord has not fixed the code violation with a certain time, we will prepare the notice of infraction and refer to the civil infraction or the enforcement division. And from there, we can find the landlord if they do not abate the problem, or at the same time fix the problem. And if they still don't fix the problem, we refer to the Office of the Administrative Building or partner with the Office of the Attorney General. These are photos, examples of housing, substandard housing condition: leaking roof, broken down cabinets, horrible basement, sewer backup. The life cycle of housing code inspection is the same that I explained to you. We take the complaint. You can call 442-9557, option 6, or you can email us, dcra.housingcomplaints@dc.gov. Once we discover there's a code violations, we cite the landlord and mail the notice of violations. And then if they still don't fix the problem, we refer to the OCI or OAH. The landlord has the opportunity to request for extension, but we will not grant the extension to abate the problems if they're not actively making repairs. Notice of infractions are the documents or the next step if the landlord has not abate the problem within a certain period of time. The notice of infraction will be referred to the OCI or to OAH
Okay,
Or-
Mr. Gamble, let me interrupt you
Sure.
just to make sure that this gets locked in. Your staff goes out, they do an inspection. They say, oh my God, major problem. They write a report. There's a notice of violation issued. Is the housing provider assessed a fine at that time?
We will wait for the first day before we can issue the fine. It takes a process. We have to prepare the documents, accurate documents. Then we refer to the Office of the Civil Infraction. Then that's the only time either we can impose the fine to the landlord, not before the preparation of the notice of infraction.
And I'm wanting to really lock that home because I don't know how many times people have called me. DCRA came out. They found this. They're fining them $7,000. Maybe. Now, I think there's a misconception that often happens there. It's only after a repeat inspection where the problem is still not been addressed and that they start the process that leads toward the assignment of a fine. Okay, go ahead.
Correct. So even though the landlord is assessed $7,000, let's say in the notice of violation there were 5 items, and each item has corresponding notice of amount. When we come back for reinspection and we found that 2 of them have been abated, then that 7,000 is no longer 7,000. We will deduct the 2 items that have been abated from that $7,000.
Okay, short answer time because of where we are on the clock. Mr. Gamboa, I keep hearing these rumors that there's a thing called a nuisance abatement fund. My question is, if there is one, what is it and how is it used?
Nuisance funds are used to abate the problem if there are severe code violations existing in the unit and the landlords are not responding, they're not responding to the code violation to make repairs or to abate the problem. We stepped in, DCRA stepped in and make the necessary repairs. We use that nuisance funding to repair or fix the problem.
Okay, now, just to put it in perspective, how often has that fund been utilized, say, this year?
Not always. It's a very occasional, very rare occasions when there's a really life safety involved. Then that's the only time we stepped in. We one of the cases that we did was we spent about $500,000 to fix the entire building because the condition of the building is so severe. You would not live on that building. So we stepped in and fixed all of the units. And when we fixed the units, the tenants were able to come back.
Where was that property?
5509 9th Street or the
Well-
931 Kennedy.
We'll talk later. Jimmy, I know that the housing providers of this city are willing to spend their last penny to make sure their property is in great condition. Sometimes they spend more than their last penny, I've heard, and they have to declare bankruptcy. Has that ever come into play in your cases?
It has, and in fact, this is something that that came up in the Terrace Manor litigation, which is currently pending in the Superior Court. And this is a case that involved a partnership between Jane's unit and the Office of Consumer Protection. The Housing and Community Justice filed a petition for the Tenant Receivership Act, and we've included in that petition consumer claims. And the receivership component under the Tenant Receivership Act was progressing forward. And the day before filing for the receivership in the litigation, you have to go through a process of generally first the judge is going to allow a landlord to try and address issues through an abatement plan, and when that falls apart, then you can ask for the receiver. So we gotten to the point in the case where we're going to be asking for the receiver, and the night before the Terrace Manor LLC, the entity that owned the apartment building, declared bankruptcy. And so then that moved a component of the case, theoretically, so the landlord claimed, into the bankruptcy court. And ultimately, we were able to convince the bankruptcy court that because the government was bringing claims in an enforcement action, that the bankruptcy didn't stop our case from going forward, and Jane's unit was able to go ahead and get a receiver put in place, even though the bankruptcy was proceeding. The bigger issue is that the bankruptcy filing allows the building to be sold without TOPA being followed. And so our office felt that it was important both to defend the fact that a bankruptcy filing doesn't stop our enforcement action, as well as that a bankruptcy action filing shouldn't allow TOPA not to be honored. That we also, inside the bankruptcy action, we filed a motion for bad faith and asked the bankruptcy court to dismiss the bankruptcy. And the bankruptcy judge disagreed with us and said that no, there is inside TOPA an exemption for a bankruptcy sale. And even though there might be some suspicious facts here that might cause us to question whether or not there's truly financial reasons for the filing of the bankruptcy, because the council has permitted a bankruptcy exemption in TOPA, the bankruptcy court has allowed the bankruptcy process to go forward towards a sale without TOPA being honored.
Okay, now one more word from our sponsor, OTA. If you are unfamiliar with what he's talking about when he says TOPA, Tenant Opportunity to Purchase Act, you really should become familiar with that. It's a very valuable right. It's constantly under challenge. And I would suggest that for the next session, you go down to room 4 where they're doing their Renters 101 presentation. And I believe it's in part 2 that they will be talking about TOPA, and I would encourage everyone to become familiar with it. Now, let's go, Mr. Gamboa, a very short answer. I understand that there have been some changes made to the amounts of fines that DCRA can assess. Am I right about that?
Yes, we are.
What do they need to know?
Currently, it's not out there yet, but we are in the process of raising the fines to encourage more landlords to abate the existing problems in their units.
And how much are you raising them?
Right now, I can't say the exact amount because it's still in the process. It's still in the dynamic condition, so it could be higher, but I can't tell you the exact amount right now.
Okay, so stay tuned for that one. Ma'am, you had one more question?
Go ahead.
Oh, go ahead, sir.
I have a question, which is, are there guidelines that you would suggest or recommend for documenting items for evidence, such as for the tenant, including such things as date and time signature and recorded images and audio, place documents online so that one could say, they've put it on the line and third party is providing the time signature and date. Hand off a recording to a third party who is recognized by the appropriate agency as a respected source for being a repository or holder of the information.
That's a great question. I'll say that I don't have a Dropbox to offer people, but you're getting at one thing that's very real is sometimes our tenants have taken photographs with their phones. You know, a lot of people now have phones with camera capability, and those are important pieces of evidence, but they don't have anything showing when they took those photographs. So it's very important if tenants are working to take photographs and document things that they have a way of, sending it to themselves or someone else via email, maybe with a note in that email to themselves saying, I took this photograph today. Also, sometimes you can't tell what unit a picture is in. It's just a picture of a moldy corner. I don't know where that is. It's very important that at the time, if people are taking photographs, that they also find some way concurrent with taking the picture to record what the pictures of and where it was taken. I also want to say, since it's almost 3, I'm sure people have a lot of questions about these things, and I know I have a lot to say about these landlords and these cases. So if you didn't get to hear something today, you have my email address. We are always happy to come and present to groups who want to know more about the tenant receivership cases or our other housing related work or the wage theft work. Please email me. You can also email James Pittman, who's the head of our community outreach team at OAG, james.pittman@dc.gov. He gets a lot of requests from groups for presentations, and he forwards them all to me, and the attorneys and I will come out there and answer all your questions about our housing litigation.
Okay, Mr. Gamboa, 15 seconds, last word.
So you can call me if you have any questions or complaints at 202-439-3285, or you can email me at ferdinand.gamboa@dc.gov. It spells FERDINAND.Gamboa, GAMBOA @dc.gov, or you can approach me later. I'll give you my business card.
Okay, you just got the desk number for a DC government executive. That doesn't happen every day. Jimmy, your 15 seconds.
Sure. One thing I just want to give a quick plug on some legislation that is coming up on the fine issue. We have some consumer protection legislation amendments that will be coming up in the council in 2 weeks. And one of the things we're going to be doing is increasing our fine amount up to $2,500 for an initial violation and $5,000 for a second violation of the CPPA. So if you contact the council on a regular basis, you might just mention to them you think that's important. And I'll tell you the reason that it's important for us to do that is that in the district we're a small jurisdiction. Our fine amount and the consumer angle and the consumer area is one of the smallest in the country, but we have fewer consumers. So it's important from a enforcement perspective for us to have a larger fine amount as a way to incentivize companies not to violate our law.
Okay, folks, I would like to thank our 3 panelists who've done a wonderful job. First of all, may I? Thank you.
Thank you for that.
Second of all, I would like to thank our fine audience. You too have done a wonderful job. If there are further questions, Ms. Lewis has volunteered to be standing outside the door here for a few minutes afterward. Note, not sitting right here because there's another presentation getting ready to come in and take over this space. If you would please take your evaluation forms, and I'm going to ask if you would give them to this fine gentleman in the black shirt that volunteered before. I appreciate it very much. And I believe there are refreshments somewhere out in the common areas, just in case you have any room left for anything after this dinner. Thank you all very, very much.